Thanks. So yeah, I'm here to talk about my work at my law firm, Basile. We're a national IP law firm, and we happen to be a founding member of the QED-C. I'll start off with a few fun facts about our firm, and then I'll address what some of you may be wondering: why patents, why now? And I'll finish with a few tips to hopefully leave you something useful. First fun fact, our firm was founded the year I was born, 50 years ago. We have attorneys in various US locations. We specialize in patents and IP, but we also have litigation and corporate practices. Our corporate law offerings include employment law, startup law, mergers and acquisitions, in which we recently helped one of our startup clients go through the process of being acquired. And this link describes some of our offerings for startups. Another thing that many of our clients in the quantum space appreciate is that we can speak their language because of our backgrounds. In addition to our experience patenting quantum computing hardware and software, our own academic backgrounds include work in quantum communications, quantum sensing, and yes, that is my actual lab from my MIT days, and my lab mate tucked back there who went off to become an engineer at a large QED-C company. When we ask why patents are relevant now for the quantum computing industry, one thing that becomes clear is that the number of patents being granted in the US and around the world has been growing in the last few years, as shown in this chart from one of my recent talks on patent trends. But just because people are getting patents doesn't necessarily mean the industry is mature. So I want to answer the question some skeptics may ask: if most patents are never litigated or licensed, why are they relevant, especially when significant commercial activity and standards may be a decade or more away? I will first point out that a patent that has a 10-year lead on the field in an industry that will be mature in a decade is being filed today. There are also certainly true innovations, the crown jewels, that can be a primary reason to seek patent protection. There are also reasons to build a strategic portfolio, such as for due diligence that will occur in funding rounds or mergers and acquisitions. And thinking ahead for when standards do come, it could be useful to have patents that can be submitted as standard essential patents. Now, I'll mention a few tips for patenting emerging technologies. Provisional patent applications can be useful as a low-cost way to secure a filing date, especially when the technology is advancing at a fast pace and getting out into the world. But there are potential pitfalls that are important to avoid. Skimping on things like a full set of claims or thorough support for what's being claimed can risk the loss of the right to claim the benefit of that provisional at a future date. Another area where it's helpful to have a team like ours is when it comes to defining jargon and translating concepts into understandable descriptions. And when dealing with academics used to writing for publication, like those in our university and startup clients, where a lot of the founders come from academia, there's a key difference that should be understood between the academic world and the patent world, including differences in the ideas that make for good science and those that provide strategic protection. I'll end with a few tips for building a cost-efficient patent portfolio to make the most of a limited IP spending budget. It's important to use time in smart ways, both the time of the inventors and my time as patent counsel. It helps for us to talk to the engineers that are bringing products to market about their problems they're solving. And for the time they do spend writing up those ideas, a little training goes a long way. For example, one simple guideline of avoiding color in their diagrams can end up saving large amounts of time and budget later. As patent counsel, we want to make sure we understand your business goals to inform the guidance we provide. We can make sure the application is effective for each of the different audiences it may have, not just the patent examiner, but also investors, competitors, maybe even a judge and jury if the patent's ever litigated. And finally, I'll just say that there are a variety of other considerations that can have a big impact on how the overall IP budget is spent. I don't have time to go into it all, but we have a guide on our website with a variety of suggestions. Feel free to reach out if you want to explore possible ways our firm can help.